didn't the trial court make basically a credibility argument based on the evidence presented and did not basically agree with your expert witness, but rather accepted, based on the credibility and the testimony, your opponent's expert witness? And what I'm having difficulty with is reading through the brief. Are you asking us to reweigh the evidence, to reweigh the credibility, to basically discount the trial court's conclusion in this matter? That's where I'm having a problem with. And if you could address that for me.
Yes, Your Honor. No, we are not, as against what the appellee would have the court believe, asking for a reweigh of the evidence. What has occurred here is that these credibility determinations, Your Honor, it's clear from the final judgment that the court has misapplied the evidence to the standards set forth by the 13th Judicial Circuit trilogy of cases in Matthew Dick 1, Matthew Dick 2, and the Gilbo-Robbins decision, Your Honor. What's occurred here is the judge has viewed and misinterpreted that standard set forth, and in fact points to it in their own footnote in paragraph 2, where the court itself says in footnote 2 of their opinion, says, the court notes the difficulty this trio of appellate cases, which establishes the test and respective burdens with regard to the prevailing competitive price, has caused. This has caused great confusions not only with the parties, but also on the trial court in determining precisely, and this is key, what evidence is sufficient in establishing the prevailing competitive price. In particular, the reference to non-insurance transactions and what constitutes the same. It's clear that the court's confused by the standard that's set out by these trilogy of cases. And if you look to the court's order, when the court's trying to determine, did GEICO pay the prevailing competitive price? How can the prevailing competitive price be proven or identified? To me, that's answered in that footnote.
The only evidence that was put on about prevailing competitive price had to do with contracts that GEICO was party to.
Your Honor, there's no evidence of that in the record. There is no contract that was executed by GEICO or any other party that was presented in evidence.
I mean, correct me if I'm wrong, but my reading was that during trial, no evidence was put in about the prevailing competitive price.
Yes, Your Honor.
As compared to what Shazam was charging.
No, Your Honor. I think that is an inaccurate recitation of the evidence that the court viewed.
I guess more specifically, evidence was put in, but only with respect to contracts that GEICO was party to or had an agreement with the glass company.
Your Honor, there is no evidence of an agreement in this record. There's what's referred to as the GEICO glass pricing letter, Your Honor, which is simply a notification that's addressed to no one that GEICO sent out. The testimony is that GEICO sent this letter out to every shop in the state telling them this is our parameters. It's nothing more than a notification. It's countersigned by no one. It's executed by no one. It can't be an agreement. This is the confusion.
Well, regardless of whether it's an agreement, isn't it inherently inconsistent with the notion of competitive price?
Your Honor, I think the 13th Judicial Circuit.
Hey, this is what we're going to pay, not, hey, we're going to pay the prevailing competitive price.
Your Honor, I would state that's how our market works in every instance. You have
that's not what the insurance contract says.
The insurance contract says they're going to pay a prevailing competitive price, which is the price.
That is people to shops that are competent and convenient.
Right, but it's also defined in the policy as the price that GEICO can secure. Your Honor, take a transaction with General Motors. If someone wanted to know how much a certain vehicle would cost, you'd go learn about what the transacted costs were for a given number of vehicles in a given area from relevant different dealerships. You wouldn't ask them, how did you arrive at the final sell price, or how did you determine the list price? No, you'd want to know, what are the competitive players in the market transacting at? And it's exactly what GEICO introduced. And it's the trial court's misunderstanding that any transaction involving GEICO with a ready, willing, and able non-affiliate shop that bills Geico at Geico's parameters, that transaction can't be a competitive transaction. And that's a complete misapplication of the standards set forth in Matthew Dick 1 and the other two cases, Your Honor.
But if I may, Mr. Trowell, isn't that the prerogative of the trial court? Your expert didn't really come out and say specifically that for those places, he basically was kind of very narrow in his conclusion, and comparing that with Shazam's expert that went through and explained exactly why this ought to be what is the competitive price versus the non-competitive price. It's a battle of experts. It's not a matter of that the court discounting, very unrebutted testimony. There is a dispute as to what would be the prevailing competitive price, and the court basically came to a conclusion, circling back to my first initial question to you, as a credibility, the trier of fact, he chose to reject your expert and accepting Shazam's expert.
Yeah, Your Honor, but if we ignore the fact that she's misapplying the standard, so if you set off a standard and you've excluded a certain type of evidence, and that's the evidence that one party relies on, certainly the court's going to come to a credibility understanding. The problem is her understanding of the standard is the error we're seeking to reverse here. Matthew Dick 1.
I guess, Mr. Trowell, I'm trying to understand, because as I read the transcript, Geico's taking the position, these are the folks that we deal with, and we're telling these folks, this is what we're going to pay. Just by virtue of them saying, this is what we're going to pay, or this is the parameters going to pay, that does not make it competitive. And those companies choose to do that. That really doesn't come to the conclusion that is, according to the contract, what is a competitive price. And given that, with the testimony presented at trial from another expert that brought this to light to the court, that this is what Geico has done, and basically bring in evidence as to what would be the competitive market price, that's where I think I have an issue and a concern with your position in this case, that you're not asking us to reweigh the trial court's determination as to the credibility of the experts.
Yeah, Your Honor, I don't believe we're asking you to do that, because I think we think the error is the application of the standard, and how the judge views the evidence within that standard matters. It creates error. And to answer your question, simply sending out a notification of what we pay doesn't mean it's not a competitive price. It's no different than how any of us transact in any market. The price is known, and whether or not you're going to have a meeting of the minds and you're willing to transact at that price creates a market transaction. Okay, there is a published price, but that price doesn't become a market transaction until someone actually agrees to the price and transacts at that price. And what we have to look at here is the trial court's interpretation of prevailing competitive price under Matthew Dick 1 and Matthew Dick 2. They entered a pre-trial motion in limine that says, Geico, you can't rely on any transaction where Safelite was performing the windshield, because you have an actual agreement there. You can't rely on any affiliate transaction. Affiliate shops are non-Safelite shops but are a member of Safelite's network. You can't rely on that because they're a part of Safelite's network, despite the only testimony about affiliate shops being that they are free to accept and reject the job based on the pricing. So they are a ready, willing, and able buyer. But even against those odds, Geico only presented transactions with non-affiliate shops, not non-affiliate shops that Geico only transacts with. These are non-affiliate shops that have no relationship, no contract. There's no evidence in the record of a contract. And these are shops that Geico understands that there's a loss. They understand that their insured has identified this shop. This is the way one of these transactions occur. Geico transmits a work order, just as they did here in Shazam, and Shazam admitted to. That work order says, here's what we're going to pay. And the shop at that point can choose to accept the job and replace the windshield. And that's the evidence we presented. And what Judge Valkenburg said in paragraph 26 of her order is Geico presented only evidence that involved transactions in which Geico was involved in. What other evidence is there in the face of Matthew Dick 2, which states that any other transactions related to other insurance companies are irrelevant. That's what Matthew Dick 2 says, because the policy language isn't the same. So the only transactions that can be irrelevant are transactions that have been adjusted under Geico's policy. And here you have non-affiliate shops, but the way the court is applying the evidence in paragraph 26 through 30 is that any transaction Geico's involved in is an insurance transaction and irrelevant. And any transaction Geico's involved in that they show that they are securing at that at their parameters can't be relevant, because the judge is saying they must be pursuant to an agreement.
Well, let me ask you, Mr. Trowell. I mean, the evidence in this case showed that Shazam set its price in part, and largely, I think, based on the NAGS schedule. Couldn't the court, and he said, does it based on the NAGS schedule, based on consulting other shops and to come up with a price that's reasonable and competitive? Did you offer any evidence that it wasn't? I mean, why couldn't the court accept that testimony and say, yep, that's the case, and that fits the definition under the statute? And just because you're under the policy, and because you seem to be unwilling to pay that doesn't alter your obligation under the policy.
Well, neither party offered any evidence with respect to what NAGS is or isn't, other than a published list price. In fact, when Mr. Martineau was asked in the record about the preface of the NAGS publication that indicates it's not indicated to be a retail price, he wasn't aware of it. So that was the only real testimony about what NAGS is or isn't. Both parties have what I would call parameters. Shazam applies, let's look at the NAGS list price. We charge 100% of that.
My point is, he says NAGS, consulting other shops, informer surveys with other shops, etc. Why wasn't that sufficient to show that was a competitive prevailing price, and therefore they went?
Well, Your Honor, first of all, I think that the burden was thrust on Geico to prove the prevailing competitive price. I don't think the court is indicating that Shazam has proven the prevailing competitive price. I think they're saying Geico didn't prove it.
Paragraph 17 of the order, the court points out that Dr. Mellish opined that Shazam's invoice pricing was consistent with the invoice price submitted by other non-affiliate shops in the Tampa Bay market. In other words, finds that Shazam was appropriately setting their prices, and the court heard that testimony from expert Mellish and accepted it, and that's the basis of the ruling.
Well, Your Honor, that goes on, Judge Black, that goes on to paragraph 24, where the court holds that Shazam's pricing was usual and customary, fair and reasonable, which is exactly the grounds for which Matthew Dick 1 was reversed, because the underlying trial court held that the pricing by the shop was usual and customary and reasonable. That's not the standard that Matthew Dick 1 set forth, and it's certainly not the language of the policy. It's prevailing competitive price. And we urge that the policy says it's what we can secure, which makes sense. That's what is a market price. What is being transacted at? Where are the parties having a meeting of the mind? So from that perspective, we continue to think that the court's application of the evidence is misplaced, and in essence in paragraph 26, throwing out any non-network transaction where Geico was operating at its parameters, simply because Geico was involved, and simply because these non-network who have no agreement, there's no agreement in the record, were willingly billing Geico pursuant to these parameters and accepting the job and performing the work. Now, moving on to Geico's affirmative defense as to waiver, Your Honor, we believe Geico presented sufficient evidence of waiver in this case. The court has judged the standard, misapplied the standard. The judge is indicating that to prove waiver, one must show that there was, in essence, a tacit actual agreement. That flies in the face of Florida's standard jury instruction, which clearly states a waiver may be oral or written or may arise from the conduct which shows that the claimant gave up the right. Shazam's corporate rep testified that not only did he receive the Geico work orders, this is at the record at 5168, not only did he receive the work orders in 3 of the cases, not all 4, he then states, but you knew what Geico, as you said, wanted to pay on these claims, correct? Yes. They communicated to you what they wanted to pay, correct? In the 3 cases, yes. So prior to him deciding to perform the replacement, he knew exactly what Geico was going to pay and chose to perform the service.
Mr. Trowell, you are at your rebuttal times. Proceed as you wish.
Okay, about 1 more minute, Your Honor.
Sure.
And citing to, in our brief, A&E Auto Body Inc. versus 21st Century, as courts have explained, and this was in a quantum merit claim, Your Honor, as courts have explained, in dismissing the claims against Geico and other insurers, where the repair shop proceeded to make repairs after being advised by the insurer how much it would pay, with foreknowledge of the amounts defendants were willing to pay, the plaintiff could not have any reasonable expectation of receiving more. That's what happened here. We presented the work orders were admitted into evidence. Mr. Martineau admitted receiving them. He admitted understanding what Geico was willing to pay prior to performing the service. We believe he's waived any right as an affirmative defense to collect additional monies, and I'll reserve the rest for rebuttal, Your Honor.
Okay, you have right at 4 minutes.
Thank you, Your Honor.
All right, Mr. Caldevilla.
May it please the court, Your Honor, I'm Dave Caldevilla and I represent Shazam Auto Glass in this appeal. This is the 3rd time that Geico has appealed from a closely similar final judgment issued by Judge Valkenburg, sitting as a trier of fact in a non-jury trial, where she found that Geico failed to present credible evidence. In August 2022, in Geico versus Glasgow, which is case number 2D21-359, a panel comprised of Judge Northcutt, Judge Rothstein Yorkham, and Judge Stargill issued a PCA affirming a practically identical final judgment issued by Judge Valkenburg. More recently, on December 28th, in Geico versus Superior, as a signee of Fontaine, that's case number 21-2593, a panel comprised of Judge Northcutt, Judge Black, and Judge LaRose issued another PCA affirming another practically identical final judgment issued by Judge Valkenburg. And if you go back and look at Geico's initial brief in the Superior appeal and compare it with Geico's initial brief in this appeal, you'll see that they're basically carbon copies of each other. So as in the Glasgow appeal and the Superior appeal, Geico is once again inviting this court to ignore Geico's burden of proof, reweigh the evidence presented at a two-day trial, and disregard fundamental principles governing the standard of review, preservation of error, and the presumption of correctness. Since the dates of the Glasgow appeal and the Superior appeal, the controlling law has not changed, and neither have Geico's erroneous arguments. So to quote Yogi Berra, this appeal is like deja vu all over again. Under the standard of review, the trial court's finding of fact in a non-jury trial are clothed in a presumption of correctness. They can only be reversed when they're unsupported by any competent substantial evidence, and the appellate court is not allowed to reweigh the evidence or engage in de novo fact-finding. Geico wants to turn that standard upside down by portraying the evidence in the light most favorable to itself, instead of the light most favorable to the trial court's determination. And we just heard that from right off the bat, Mr. Trowell's argument about waiver. Geico presented sufficient evidence of waiver. That was his argument. That's not the standard. The question is whether the trial court's rejection of Geico's evidence is supported by the record, and it certainly is. And I'll get to the waiver argument, but counsel argued that this burden of proof was thrust upon Geico. That's not so. In this case, it's undisputed that all 4 of the windshields is a covered loss. Geico admitted that. And so therefore, the primary issue at trial and on this appeal is whether Geico met its burden of proving those 2 affirmative defenses. The first being that Geico's payment amounts complied with the prevailing competitive price provision in the insurance policy. The second is that Shazam waived its right to recover that price. So both during and at trial, Geico conceded that Geico had the burden of proof on both of those affirmative defenses. It wasn't thrust upon them. They said right at trial in their opening argument at page 5097 of the record, Geico has the burden, Your Honor, the burden as to its affirmative defenses, both the prevailing competitive price and waiver, Your Honor. They admitted they had the waiver. That's the law in Florida. The insurance company has the burden to prove these limitations, and a waiver is clearly an affirmative defense as well. Geico presented, their problem is they presented no credible evidence to support the limitation of liability defense. Now, counsel says, well, look at footnote 2 of Judge Valkenburg's final judgment. By the way, that same exact footnote was found is in the Glasgow final judgment and in the Superior final judgment. Doesn't matter that the judge was pointing out that, hey, there's this non-insurance transaction element or statement that the Dick case has thrown into the mix here. What matters is if you go to paragraph 29 of the final judgment, Geico's evidence has no credibility. She says on paragraph 29, neither of Geico's witnesses created or generated the claims history spreadsheet. None of the data listed on the claims history spreadsheet was adequately verified as being accurate or corroborated with any of the underlying billing and payment records summarized therein. Geico also failed to present credible evidence that any of the windshield shops listed on the spreadsheet were competent, conveniently located, or in a position to perform any of the insured customers' windshield replacement jobs at the time, date, and place requested by these four insured customers. Further, there is no information regarding whether the amounts paid were ever contested by the receiving company or whether additional payments were subsequently issued by Geico. Let me explain that. This claims history spreadsheet identifies, and there's 69 transactions per page, and it's over 100, it's about 150-page document. And each line of that spreadsheet is a summary of information plucked from other documents without presenting any proof of the underlying document. It's an irrelevant and inadmissible piece of evidence from many levels, but the trial judge went ahead and let it in. This is a non-jury trial. She let it in, but she recognized this evidence is worthless. Geico admits that when they put down the price that they pay on that spreadsheet, assuming it's accurately transcribed, if they say they paid $500 for a windshield, if Geico later determines that they underpaid that claim and they issue an additional payment to the windshield shop, it is not reflected on the claims history spreadsheet. So they do not update it to put the correct price that they actually paid. And we don't know how many transactions on the spreadsheet had that situation going on. So it is inaccurate and unreliable at the outset, not to mention the fact that Geico refuses to present any of the underlying records that they used to create that monolithic piece of hearsay. Another giant problem that they had, and this had nothing to do whether it's non-insurance transactions or not, it just has to do with this claims history spreadsheet cannot be relied upon. It's inadmissible. The other problem was their own expert. In paragraph 30 of the final judgment, the judge says, Geico's expert witness, Dr. McClave, did not credibly establish that his analysis was based on adequate, relevant, and accurate data or an appropriate and reliable methodology. It doesn't matter whether it was insurance transactions or non-insurance transactions. He didn't verify the accuracy of anything he relied upon. So what does this boil down to? Geico says, oh, well, they thrust this impossible burden on us. No, Geico, you know how to prove this case. You filed 100 and something page motion at page 539 of the record called Geico's motion for continuance to determine infeasibility of a 2-day trial in light of defendant's material witnesses. So this was a motion where Geico said, Your Honor, we have 169 witnesses who are corporate representatives from 169 windshield shops, and they're going to testify because we have the burden to prove that Geico could have secured a price from a competent and conveniently located windshield shop, the same prices that we paid for these 4 windshields to Shazam, we got to call 169 witnesses, or we're able to call 169 witnesses to prove that these shops would have accepted the lowball prices that we paid to Shazam. This was a big bluff so that they could get a continuance. I'm sorry, did somebody shout? That was a bluff so that they could get a continuance. But if you read that motion, Geico understands clearly what its burden is. And that is to put on some windshield shops, put on a number of windshield shops who say, yes, we're competent. We've changed windshields on 2011 Kia Souls and Mercedes C230s. We've been changing them for years. And you know
Mr.
what?
Caldevilla, so isn't that the bottom line? This was just a trial on a battle of experts, that the court simply rejected one and accepted another, and not
Yes, Your
really
Honor.
as to the exact competency of the testimony itself. I mean, you know, the trier of fact could weigh the credibility, could agree or disagree, disregard, approve, disapprove any factual determination before them. Isn't this, in a way, Geico's asking us to reweigh the evidence of the trial court entered
Absolutely.
below?
Absolutely. That's exactly what they're doing. They're trying to portray it as, oh, the judge used the wrong legal standard. But the only thing they can point to is this footnote 2, where the judge says, well, I'm not sure what Dick means as a non-insurance transaction or not. But it doesn't really matter because it just said all their evidence lacks credibility. It doesn't hinge on this non-insurance transaction issue that the Dick decision talks about. And Geico never once complained about the Dick 1 case. In fact, they told the judge that she's required to comply with the Dick case. And now they want you to reverse it, basically. They're asking through the back door, please reverse the Dick case. In a few weeks, Judge Northrup, you're going to hear the Dick appeal. And Geico says in that case, well, the Dick standard is correct. In this case, they're saying, wow, it's confusing and you shouldn't follow it.
Yeah, you know, I ever since our jurisdiction changed, I'm seeing a lot of you guys.
Becoming quite an expert, you all becoming quite experts on small claims and windshields, and so am I. With respect to the waiver argument that Mr. Trout touched upon, let me point out that Geico doesn't want to mention that their own policy says at page 5734 of the record, their insurance policy says the terms and provisions of this policy cannot be waived or changed except by endorsement issued to form a part of this policy. All right, so they're saying, so once the policy itself says you can't waive anything in this policy, but they're saying that my client, of course, did waive it. How? Because we sent you a work order telling you what we were going to pay. Well, my client is standing in the shoes of the insured. The insured negotiated or got an insurance policy from Geico where Geico said the amount that they were going to pay. They negotiated with my insured and said, we're going to pay the competent, the prevailing competitive price, which is the price we can secure from a competent and conveniently located shop. So then Geico sends out this work order, and this letter says, well, we're only going to pay half of the fair market value. So like it or not, that's all you're getting. Well, the windshield shops that's not part of the policy. It's nothing. It's just a Geico being a bully saying we're just going to pay half. So live with that and don't pay any attention to our policy because we're not paying any attention to the policy. That's just not the way it works. But Shazam didn't waive anything. There's no evidence of it. Certainly, the judge's findings on the lack of waiver in this case are clearly supported by competent, substantial evidence in the record. So just like Judge Kuzam says, this is just an attempt to reweigh the evidence. Although Mr. Trow hasn't mentioned standing, he raises in his brief that Superior has standing, and that there was, according to him, the assignment of benefits that was signed by their insured is inadmissible. This is clearly a business record. The predicate for demonstrating the hearsay exception for business records is clearly in the record at pages 5126 through 5138. Once that burden is met, the non-moving party has a burden to prove that there's a lack of trustworthiness. There's no evidence of that. Instead, Geico relied on that assignment of benefits and paid what it contends was the full amount that it owes. They say we paid every penny. But how can you say that the assignment of benefits was not trustworthy when you relied on it? In fact, the ITT real estate equities case by the 4th DCA says exactly that. When there's a written instrument offered against a party, it's presumed to be genuine by proof that the party against who the document is offered has acted on it as being genuine. That's exactly what happened in this case. I don't know that I really have much more to say than what's already presented in my brief. I think now we're at the third identical appeal by Geico. They've beaten this dead horse to death, and I request your honors to affirm. Thank you.
Thank you, Mr. Caldavia. Okay, Mr. Trowley, you have 4 minutes for rebuttal.
Thank you, Your Honor. I will address the burden of proof. The trial court erred in requiring Geico to prove that it did not breach the policy of insurance. And as discussed, obliterated Geico's ability to meet such a burden by the misapplication of the evidence, not a weighing of the evidence, a misunderstanding of the standard, and therefore a misapplication of the evidence. Shazam's statement of claim asserts a breach of contract claim. It states by failing to make a payment as described in the insurance policy. The prevailing competitive price, the limit of liability in the policy, is not an affirmative defense. The cases the 13th Judicial Circuit rely on and Shazam relies on in Matthew Dick 2 and Gilbo Robbins, State Farm v. Curran, are all distinguishable. In State Farm v. Curran, 135 Southern 3rd, 1071, Florida Supreme Court, the suit arose out of a denial of coverage, and such denial was not premised on a coverage exclusion or limitation, but a denial of coverage in its entirety. We all know that a denial of coverage is clearly the burden of the insurer to support that denial of coverage. So it didn't arise out of an exclusion or a limit of liability. In St. Paul Mercury v. Coucher, 837 Southern 2nd, 483, is similarly misplaced. In that case, the insurer's position was that coverage was available provided the amount of liability exceeded all other available liability coverage. In other words, coverage is excluded altogether under the other insurance clause. Again, an exclusion is clearly, the burden is clearly on the insurers. That's the standard of law. Here, the prevailing competitive price is not an affirmative defense. Remember, an affirmative defense is one that admits the underlying cause of action, the breach of contract. Geico is not admitting that it breached by failing to pay the appropriate amount and therefore seeking to be excused from that breach. That would be waiver. Prevailing competitive price, the burden should be on plaintiff to prove that Geico didn't pay pursuant to the policy as alleged in the claim. The most relevant case, which is cited by us in our brief, is U.S. Liability v. Bove, 347 Southern 2nd, 678. That's a 3rd DCA decision, where there's no dispute between the parties whether a particular loss is covered. The plaintiff has the burden of proof. Geico is not disputing coverage. On the contrary, Geico paid for them, and it is plaintiff that is disputing whether Geico paid appropriately under the policy. Therefore, the prevailing competitive price cannot be an affirmative defense. I go back to the errors, Your Honor. We talked, Mr. Caldavia talked about the claims history. This isn't a weighing. Clearly, a piece of evidence would lack credibility if you hold that no transaction that Geico's involved in that was conducted at Geico's parameters are relevant. Well, then certainly the claims history isn't credible because it presents transactions Geico's involved in under its policy with non-affiliates that transacted at those parameters, i.e. pursuant to the policy, it's showing actual transaction where Geico secured the price, Your Honor. With respect to these supplemental payments, that was addressed in Matthew Dick 2, where the court said, moreover, that Geico has previously paid some invoices that in full is misleading, where there are signs the invoices were disputed, i.e. subject to litigation. Mr. Martineau testified as much, that the only time in which his invoices were paid in full is when he brought litigation and they were settled in the context of litigation. Your Honor, the waiver claim is no different. We seem to be hung up on this idea that Geico is sending the notice letter of the prices and the work order, Your Honor. This is no different if you got in an accident in your car, an adjuster showed up, they present an estimate of what it's going to take. You either accept that total estimate or you don't. That is what the work order is. That's what Mr. Martineau said he received. And that is exactly, and he chose to do the job, and now he seeks payment of more. That affirmative defense should be reversed. Judgment should be reversed, and judgment should be entered in favor of Geico. Your Honors, thank you for your time.
Thank you both very much.
Thank you.
In order to leave our virtual courtroom, you click the leave button and you'll be gone.
Thank you, Your Honors.
Take care.
Thank you.
Okay, the court will be in recess for 10 minutes.